It's Ron Coleman. We're always talking about cases. What's going to happen with this case? What's going to happen with this appeal? What if the judge does this? What if the parties do that? What are the judges going to decide? A lot comes down to judges. Judges can be single judges. These are the ones that usually preside over trials. Judges can be panels of judges that consider appeals. Here's the problem. When you're handicapping a case, when you're trying to predict what's going to happen in a case, at the trial level, you're trying to predict what one judge is going to do. At the appellate level, you're going to predict what a panel of judges is going to do. There are a number of things that prevent us from doing that, and you don't really learn about them in law school. Oh, your professors will hint at them, but it's not until you get into the trenches that you really begin to understand how it really works and doesn't work. In law school, we read cases. And the idea is to learn how to read a case. What does it mean to read a case? To read the decision in a case, usually from an appellate court, that analyzes what the trial court did and asks, did the judge apply the law properly based on precedent? Did the judge extend the law in a way that's appropriate or inappropriate, because no two cases are exactly alike? Did the judge read the statute properly? All these require a certain amount of judgment. But discretion is a very special word because it really comes in at the trial level. Appellate courts are very reluctant to overturn a judge's exercise of discretion. Conduct of the trial, organization of the trial, scheduling of proceedings, and especially admission or exclusion of evidence. In order to overturn a decision by a judge made during the course of a trial on an evidentiary matter, an appellate court has to find an abuse of discretion. That's assuming, of course, that a proper objection has been lodged. If you don't object to a judge's mistake, you can't bring it up on an appeal. In fact, I tried two identical cases that literally involved the same issues, the same parties, slightly different corporate versions of one of the parties in the Eastern District of New York and in the District of Arizona. I won in Arizona and I lost in the Eastern District of New York. Same exact case. It wasn't because the lawyers were any better in New York. It's because the judge made a lot of stupid decisions. Oh, she was wrong. And the judge in Arizona was damned good. Well, guess what? The judges are worse now. That's just a fact. But also what we see is that cases are decided based on factors that have nothing to do with what you read in the law. You can write the same thing 5 different times and get 5 different results. Judges are human. They're too human. How can you be too human? You can only be human, right? No, they're too human to be allowed the amount of power and influence that they have over society. What we need is to withdraw human conduct from the purview of the legal system. Judges need to decide a lot less about what we do in life, and they'll do a lot less damage, and they can be as human as they need to be on as little as possible, so the rest of us can be as human as we need to be to live our lives.